try to that actually deal with the intent part. Mm-hmm. Which is, by the way, I think you guys, I don't know if you use the phrase the dolus specialis, that the intentional part of genocide.
Sorry, I don't know that term.
I think it's called dolus specialis. It is the most important part of genocide, which is proving it is a highly special intent to commit genocide.
Is it?
It is the most important part of genocide.
Is it?
The most important part of genocide.
Is it really the most important part? Or do you just not know what you're talking about?
Please stop displaying your imbecility.
Okay, I'm sorry if you think the declaration of the judge is imbecile.
Don't put on public display that you're a moron. At least have the self-possession
to shut up.
So the role of special intent in relation to legally proving genocide has understandably come to the fore of public consciousness recently, as the Zionist entity occupying Palestine has perpetrated a series of deeply violent genocidal acts since October 7th. For many people, especially those like Destiny Bunici here,
Mr. Borelli.
I'm going to believe that's not controversial.
Mr. Bonnell,
Genocidal
Mr. Borelli,
intent.
I don't think so either.
The Israeli Minister of Finance on the 8th of October war.
Mr. Bonnell.
Wait, you do know how to pronounce my name. Are you mispronouncing it intentionally?
Who wants to minimise and obscure the genocidal nature of the Israeli state and its current attacks, the concept of special intent, or dolus specialis, is a readily available tool for uninformed Wikipedia warriors like Destiny, as well as more informed defenders of genocidal Israel like the historian Benny Morris, seen here embarrassed sitting next to Destiny, which... feeling shame for a Zionist is hard, so good job, Destiny, I guess. But for people like this, the simple story that the Genocide Convention innately requires the extremely high bar of special intent before something can be considered genocide is used as essentially a means of genocide denial. This has a long history, with others such as the legal scholar Günter Louis having used a restrictive notion of special intent to deny genocides of First Nations people of Turtle Island, to deny the Armenian genocide, and even to deny that the murder of Roma peoples during the Nazi Holocaust should be considered genocidal. Because of this utilisation of special intent to deny genocide, I want to do this brief video looking at specific legal theory of intent as part of the Genocide Convention. Is it the case, a case which, I've been guilty of perpetuating slightly myself, where there's a more expansive socio-historical understanding of genocide, resting against one single interpretation of a restricted legal case resting on special intent, where special intent is, as Destiny likes to say here, the most important part of genocide.
It is the most important part of genocide.
Or is it more complex? So just to be absolutely clear though, obviously genocide is a concept which exists outside of the law, and I've done several videos which really go into the sort of socio-historical views of genocide, which aren't determined by a legal understanding, but instead rest on the wider work of the originator of the term, Raphael Lemkin, and much more, much wider sociological, historical, critical genocidal studies work. And I don't want to imply here that we need to have a legitimate case in international law to invoke genocide. But rather, I want to make absolutely clear that when people like Destiny use their inexplicably large platforms to rattle off bullshit they've read from Wikipedia, their concern is not actually about understanding genocide or clarifying a specific context, but actually in obscuring an ongoing genocide in the name of a political project. And that's why I want to talk today a bit about the legal theory of genocide. Also, for my own amusement, I kind of just do want to talk a bit about how Destiny has no idea what he's talking about.
At least have the self-possession to shut up.
Of course he doesn't. He's not read anything. He's read a tweet and a Wikipedia article about it, and he barely grasps the concepts he's invoking, which is, extremely clear if you look at the rest of his understanding of the legal case at the ICJ, which either deliberately or just confusedly misrepresents and misunderstands it.
The court is not asked at this present phase of the proceedings to determine whether South Africa's allegations of genocide are well-founded. They're not well-founded. They're not even well-founded.
And it's also clear from this clip,
it is the most important part of genocide,
where he confidently asserts that the dolus specialis, the special intent, is the most important part of genocide. Now, to state this as a fact reveals an absolute dearth of understanding of genocide, not just the socio-historically understandings that we've spoken about before, but legally too. You know, if you've been paying attention over the past months as the legal convention has been repeated in varying contexts, you might have noticed already that, quote, special intent or dolus specialis, these are not actually features of the Genocide Convention. It's not written there. Special intent is not written in the convention. It's not part of the law as written. However, the specific meaning and interpretation of intent has been a subject of intense disagreement since the very drafting of the convention. So, it's this intent that it's now worth turning to. Not special intent, just intent. So, as the specific nature of what intent means is not to be found in the actual text of the convention, judges, legal academics, and jurists have had to turn to other means to interpret the bounds of intent. For those like Desnay or Benny Morris and those who believe in dolus specialis, it is case law to which they turn to bolster their perspective. Now, it can be argued that the prevailing interpretation of the Genocide Convention through case law is that it is understood as requiring this special intent, which Desnay likes to point out, and that this has an extremely high bar to prove, as it often requires, like, documents proving that a particular actor needed to act in a specific way and intended to act in a specific way, and they've written down that they are going to do it. And this is obviously very helpful. This restricted definition is obviously very helpful to powerful actors like Israel who want to have who have a vested interest in making genocide very difficult to legally prove. But it's far from an uncontroversial position, and it's far from something which is settled within legal theory. So, for example, as one of the most well-known legal academic critics of special intent, Alexander Greenawalt, points out, if we follow a strict interpretation of special intent for genocide, then letters such as this extermination order from German General Lothar von Trotha, it's like, imagine being a German called that. It's absurd. It's like being called Hans. This letter from Lothar von Trotha, which calls for the execution of all members of the Herero people on German-occupied Namibian land, might not actually be considered genocidal if we have a very strict special intent interpretation of the convention. This is because the goal of the action, as the letter suggests, is not the intent to destroy the Herero people as such, but the expulsion of them from the land Germany is occupying, Namibian land. Now, obviously, to most right-minded people, that this would not constitute genocide is patently absurd. And indeed, this evidence was enough for Germany, who paid $1.35 billion in restitution to Namibia for this genocide as a result of the UN's Whitaker Report. So if this evidence can be interpreted as being both a smoking gun for special intent and directly in opposition to special intent, then what is revealed is not that special intent, doesn't exist within case law, but that it is not a consistently defined simple benchmark. It's not something that you can simply appeal to, something which constitutes, quote, the most important part of genocide, but is rather inconsistent and quite contested. And what should also be noted here, considering Germany's horrendous opposition to acknowledging genocide in Palestine and its crackdown on those people trying to support Palestinians, is the consistency between Lothar von Trotha's description and aims during the Herero genocide and Zionist aims in their genocide against Palestine. Another instance of the contested, politically dependent nature of the role of special intent when applied to different contexts. A second issue worth confronting is regarding maybe the most well-known case law regarding special intent and probably the most well-known case law regarding the Genocide Convention being applied. And that is the jurisprudence of the International Court of Justice and the International Criminal Tribunal for the former Yugoslavia regarding the Bosnian genocide. Well, for many proponents of special intent, of the high role of special intent in interpreting the Genocide Convention, people like Gunter Louis, the case law from the Bosnian genocide simply demonstrates special intent. They argue that the decision to label the clearly demonstrable order, the written order to slaughter 8,000 military-aged Muslim Bosniak men, as the only act of genocide presented during the ICTY, bolsters the idea of special intent. Intent to kill these men is clearly documented. But this isn't a case, not a simple case, of special intent being invoked and clearly defined, precisely because the group being targeted in this specific case is not Muslim Bosniaks as such, but only those men of military age. This either implies that intent to destroy the Bosniak population is being expanded beyond just the demonstrable intent to destroy a population in whole or in part, or the intent to destroy a population in whole and in part is being expanded to include this act which excluded women and children. So intent is already being muddied. Or it's arguing that special intent is not essential to the understanding of genocide. But it gets more confusing, because this is not the end of the matter for the Bosnian genocide and the legal rulings on it. While this one act was labelled genocidal and may imply an expansion of case law beyond narrow special intent, the ICJ and the ICTY invoked special intent in the judgment as the reason for excluding other larger scale massacres during the period being judged in this case. So what results from case law is not a simple dismissal of special intent, nor do we get a simple reinforcement. Instead, the case law has drawn distinctions that appear arbitrary, both as a matter of moral responsibility and of advancing the values that the crime of genocide ostensibly embraces. In particular, the courts have struggled to maintain a coherent distinction between acts of so-called ethnic cleansing that rise to the level of genocide and those that do not. The unfortunate result is that the law of genocide has often become a tool of atrocity denial. As with Serbia and Turkey, those seeking to deflect attention from past atrocities can and do invoke plausible legal arguments to counter accusations of genocide, happily shifting the conversation. This, again, should remind us of exactly what people like Destiny and Benny Morris are doing when they invoke and reify the role of special intent in understanding genocide. They are using contradictory, obscure case law to engage in genocide denial. They want to get into the obscure technical debates and move us away from talking about the actual genocide occurring in Palestine. And I wanted to make this video to help you watching notice that, to put a stop to it, and to continue to talk about the genocide on its own terms. And also to talk about how Destiny is a Wikipedia warrior who doesn't know what he's talking about and is seemingly motivated by a frothing hatred of Palestinians. Because, you know, it's nice to shit on assholes. I didn't like that turn of phrase. It's nice to shit on Destiny. So if case law can't be relied on to show the so-called most important feature of genocide, special intent, can it be found in legal interpretations of the convention? So for decades now, legal theorists, lawyers and others have been pointing out that the special intent interpretation of genocide is not necessarily implied by the Genocide Convention, and nor should it be. To demonstrate this, many have made comparisons to domestic law, and indeed the drafters of the convention grappled with the comparison between homicide and genocide, and within that comparison is tricky legal philosophical conundrums about what constitutes intent or motive. Now, obviously there is a difference between genocide and homicide, and therefore the legal understanding of when each has occurred and intent and motive behind them differ. You would have a hard time arguing that the state murder of one individual from a specific ethnic group would be genocidal. But regarding the notion of intent, drawing comparisons between domestic law and international law, there are helpful comparisons in showing how tricky the interpreting of the convention actually is. Authors like Barta, Finzsch and Stannard point out that to be found guilty of murder doesn't necessarily imply that you need to have shown that you've left the note or that you've confessed to the murder, but that the jury can determine your guilt on a murder charge via intent and via showing a particular state of mind, which is demonstrated by your actions and by your behaviour and how you consider your actions to affect the world around you. Alexander Greenawalt, essentially argued that the Genocide Convention should take a similar route to this, whereby through actions and wider evidence we can show that there is a genocidal state of mind producing genocidal actions. This is what's described by Greenawalt as the standard of genocidal knowledge. In cases where a perpetrator is otherwise liable for a genocidal act, the requirement of genocidal intent should be satisfied if the perpetrator acted in furtherance of a campaign targeting members of a protected group and knew that the goal or manifest effect of the campaign was the destruction of the group in whole or in part. Drawing upon the Genocide Convention's core concern for the permanent loss of humanity that result from the annihilation of enumerated groups, this approach emphasises the destructive result of genocidal acts instead of the specific reasons that move particular individuals to perform such acts. By such standards as this, the legal case against Israel would be much more clear-cut. The conditions of genocide are playing out in front of all of our eyes. Intent or not, written down or not, it is there in front of us. And Greenawalt doesn't claim that this interpretation is more obviously interpreted from the text of the Genocide Convention. The point is that the convention can easily be interpreted in so many conflicting ways, but rather this interpretation, which provides less, though not zero, role for intent, more effectively fulfills the spirit of the convention while reconciling various critiques, including expansionist views of genocide. People who say anything could be genocidal now if you don't have intent. So, depending on how the long legal process against Israel works out, we may actually see case law veer more towards this view. And there's other bits and pieces of evidence that can be included in this. The Rome Statute, for example, includes a far more expansive view of intent to prove genocide, intent as part of genocide. And the Rome Statute is the international legal covenant that set up the International Criminal Court. A major thing, you would think, in understanding how intent should be understood, but has been less influential, probably because of the role of law in relation to dominant power. And you can see just how inadequate the obsession with the logic of special intent is, and how much more intuitive Greenawalt's interpretation is just by listening to Mr. Bocelli, Mr. Bonelli, Mr. Destiny.
I don't know if it would have qualified as the crime of apartheid. Just like if Israel were to literally nuke the Gaza Strip and kill 2 million people, I don't know if that would qualify for the crime of genocide.
In your eyes,
this argument is patently absurd. The murder of 2 million Gazans, the entire population there, would absolutely fall within the interpretation of genocide. It would be the clear targeting, in whole or in part, of a national group, which would have the clear effect of destroying them as a national people. In whole or in part. Absurdities about proving special intent aside. Frankly, just like it's pretty clear that slaughtering tens of thousands of people, 40,000 people at least, which is probably lower than reality because we've lost the ability to understand how many people have been killed because Israel has so comprehensively destroyed the capability of Palestinian people to account for the dead. Both Destiny's hypothetical and the stone-cold horrendous reality clearly shows a genocidal state of mind, consistent with an alternative understanding of intent as understood as part of and emanating from the Genocide Convention and the spirit of the convention. So, it's part and parcel of the logic of people who commit genocide to insist on special intent, as this very narrow understanding which is drawn from confused and contradictory case law and a very specific, narrow legal interpretation of genocide is useful specifically to obscure intent. As one critic of Louis states, let's be clear, intentions are supremely important in the world's grim record of genocide, but not because they are recorded as intent to destroy. They matter least where they look like legally decisive smoking guns. They matter most because of all the ways they are disguised. Intentions were disguised by the perpetrators of atrocities to make sure they were not called to account, and were disguised also to escape responsibility by those who should have called perpetrators to account. But that is only the beginning of the difficulties for a judicial criterion of criminal intent. Perpetrators and judicial authorities were able to disguise genocidal intentions from others most effectively where they were also disguised from themselves. By appeal to the exigencies of self-defence, by reference to the larger aims of colonisation, and to explicit measures asserting benign intentions towards the indigenous peoples who nevertheless continued to disappear. Yet the importance of intent is still being implied even in the South African legal case. The legal team did a lot of work, really good work in my opinion, demonstrating Israeli genocidal intent through different layers of Israeli society, from politics to journalists to soldiers to just the general public, and did their best to show special intent because even with the contradictory and confused case law, it still remains a powerful interpretation of genocide. This, in my view, is frankly because the law is an expression of the hegemonic workings out of power. But what the South African case does show definitively, in my view, is that there is a genocidal state of mind and genocidal knowledge consistent with Greenawalt's interpretation of the convention. So, Destiny doesn't know what he's talking about. Nobody should ever listen to him on anything, never mind this. He has no idea he's read one Wikipedia article. I don't know why he would be given such a large platform on which he could demonstrate his complete lack of knowledge and understanding. Although, I guess, it is very funny that the people were just laughing at him the whole way through because he clearly didn't know what he was talking about. Like, even in this clip, it's very clear that Muin Rabini is just laughing at him here.
Which is, by the way, I think you guys, I don't know if you use the phrase, the dolus specialis, that the intentional part of genocide.
Sorry, I don't know that term.
Because he doesn't know. He's read a Wikipedia article. He's read a couple tweets, and he's shuffling through his papers as if he has anything of relevance to say about anything besides gaming. Stick to your fucking gaming, Destiny. You're not a fucking real person. You've got nothing of relevance to say. Just stick to your gaming and shut the fuck up. Like, what? Sorry. I just really fucking hate Destiny. And one day I think he's going to be embarrassed looking back at what he did during an unfolding genocide, which was shuffle papers and talk fast as if he has anything relevant to say, to try and talk over people who have actual relevance and expertise because of some frothing hatred he has of Palestinians. He's going to be ashamed and embarrassed of himself, as he should be. He's, running cover for a genocide as it unfolds is a fucking low thing to do. And to do so incompetently that everyone's just laughing at you, even the people on your side. Like, to make Benny Morris feel shame is incredible. Just, I don't know, maybe quit your job. Get a job working in a cafe or a shop or something. Maybe it's something that you could bring some joy to the world by making their coffee someday, and not this bullshit. Fucking waste of oxygen. Oh, sorry. Got carried away there. But just to clarify again, get back on track, and contain my hatred. Interpreting intent within the Genocide Convention and through established case law is not as simple as people like Destiny and even like Benny Morris would have you believe. And I want to again clarify that we don't have to confine our understanding of genocide and what the most important part of genocide is to that which is laid out in the Genocide Convention. There are numerous reasons for this that I've spoken about several times in many different videos. But what I wanted to show you here was that even if we confine ourselves to the law, the idea that genocide and its alleged associated requirement for special intent is an uncomplicated, settled matter is an obscurant oversimplification. The claim that it is the most important part of genocide is frankly, flatly untrue, despite what Wikipedia warriors like Destiny might spew out on their inexplicably large platforms. Special intent is not a simple, undisputed benchmark which must be reached before we can call something genocidal by law. It is in fact more complicated than the Wikipedia summary he read. And the only reason to steadfastly stick to this idea is to deny the ongoing genocide in Gaza. And despite the fact that technically there is no legal ranking of genocide as a worse crime against humanity than others, excluding the possibility of genocide like this is an attempt to move the genocidal acts of the Zionist entity closer to innocence, to effectively deny the genocide, which is, in effect, to work complicitly with it. To reiterate, Zionism is settler colonialism. Settler colonialism is genocidal. To free Palestine from genocide, defined beyond the law, requires the liberation of all the land from the Jordan River to the Mediterranean Sea. Alright, thanks for watching. This was a shorter video today, but thanks for watching it through. As ever, thanks to my lovely patrons. If you want to support me on Patreon, you can do so, I guess. You can also send a one-off donation via PayPal or Ko-fi. $10 and up patrons get their names read out in the credits. So we'll do that now, and then we'll draw this to a close. So, Demo Squid, Dying of Thirst, Soval Hayes, Earl Grey Tea, Bonnie, Katie Marshall, Nina G Public Relations, FD Signifier, Quint Wolf, Kim Crawley, Anita Nisby, Ellis Wren, Sophie, Hey Joe, Cameron Blakemore, Misling, Lawrence Rowland, Cyril Smid, Rachel Ann, Melanie Estes, Laum, Xander Corvus, Via Westfall, Jack, TB Skyen, Christopher Poff, Mark Gussie, Daniel Kusid, Joshua Moldenhauer, Tom Price, Kade Soiree, Esoteric Fictionalism, Austin Talman, Robin, Rachel Mixon, Rich, Duncan Skinner, Niels Abildgaard, Tinfoil Pancakes, Kieran Gore, Aga Ghost, Barney Carroll, Joel, Daniel Hughes, Nelly Zacheva, J. Fraser Cartwright, Aaron, Tamesh Kispiter, and Paul Singleton. And thanks. So, you know, as ever, if you liked it, like and share, and, you know, fuck Destiny, I guess. Bye.